Hi, everyone. We'll just give others a few minutes to join and then we can get started. Okay, I think we'll get started. So good afternoon, everyone. Thank you for joining us for another edition of our webinar series, Inside Immigration. Today, we're joined by immigration lawyers Alexandra Cole and Peter Salerno, who will provide us with Canadian immigration tips to expand your business in Canada. Please feel free to ask any questions using the questions icon at the top of your screen. We will do our best to address them at the end. If the panelists do not get to your question, you can contact them through the information provided on the screen. With that being said, I'll hand it over to Alexandra and Peter.
Thank you very much. As was mentioned, my name is Peter, and it's a pleasure to be with everybody today. Alexandra and I were very much looking forward to this conversation. We wanted to speak with everyone today about this topic because we are meeting with clients often who are opening or in the process of starting a business in Canada. And in our experience, they often have done a lot of homework, a lot of research on, for example, tax requirements, corporate law requirements, human resources, HR requirements, and Canadian immigration is not always front of mind. And as a result, companies are sometimes, after the business has been structured and opened, realize that there are roadblocks and Canadian immigration pathways for work authorization are not as easy as initially thought. And it's sometimes more difficult to bring employees into Canada as a result. So the purpose of today's presentation was to hopefully provide listeners today and provide everyone with an idea of what to consider now at the beginning when starting up a company in order to maximize Canada's and optimize Canada's mobility policies with respect to bringing in foreign workers into Canada, and also briefly touch on some of the employer compliance requirements. So after the company is operational, hiring foreign workers, what to keep in mind in terms of compliance as well.
Thank you, Peter. Welcome, everyone. We also would love if this conversation was as practical as possible. So as Shabitha said, please do feel free to put your questions in the Q&A chat. We want to be able to cover, broadly the common situations that we see arising and provide you with a good overview of factors that we see as commonplace issues coming up for businesses. A lot of people will put, their market research, incorporation, tax compliance, all of those things at front of mind when starting a company. And then the immigration consequences are sometimes brought in as a second consideration. We feel that it's helpful to plan for those immigration factors at the same time as all of the other factors, so that at each step of the way, businesses are making informed choices and this will help facilitate their ease of market entry when the business has been created. With that, as a final note, before we get into our more specific agenda, it can be helpful to engage organizations in Canada that assist with navigating those local requirements and regulations. So there are some great organizations here that help with making connections or provide all of those services in-house as much as, incorporation goes, opening a Canadian bank account, helping with payroll and initial HR advisory services, tax compliance, early stage administration support. So that is something that can be helpful if you are sort of struggling to tie all those loose ends together when entering the Canadian market. So in terms of a entry to Canada as a business visitor, this is something that a lot of either the executive team or the lead manager or the founder of the business is going to need to do before they even open a company. It is very useful to come to Canada, do some exploratory visits, meet with some of your key partners that you might be working with when you do open the company. Those activities can normally be done preceding operations as a business visitor. They are not viewed as, working or entering Canada's labor market. So typically, if the person who's coming into Canada is from a visa exempt country, they would, board a flight. Maybe they're going to have an electronic travel authorization, which is sometimes required for visa exempt persons to board the flight, come to Canada. You'll want to have some information with you if you do get asked by border officers what you're doing in the country, but that's okay to do. If you are visa required, then you are going to have to apply for a temporary resident visa to be able to board a flight to Canada. And that is an application that needs to be made online to Canadian immigration that is processed at a consulate before you're able to travel to Canada. What I'll say on that point is if you are someone who needs to obtain a visa, it's important to get that right the first time, because it's really like the first step, the first time that you're putting yourself forward with Canadian immigration to say, I'm going to be part of this new business in Canada, or I'm doing these exploratory visits. I need this visa. And if you get a refusal on that application because the materials are unclear, or you haven't shown immigration that you have substantial ties to your home country or country of residence, that can then set you up into this sort of like domino effect where later, when you need to again use consular services to apply for the work permit, you now have this refusal on record, and it can lead to complications. Peter, is there anything you want to say about entry as a business?
No. I think that's a really good point. I have seen clients where they have had multiple visits to Canada, and they successfully enter the country, and then subsequently it just takes one border officer to make a negative finding. Even if you're entering and you are visa exempt, a border officer can inquire about why you're coming in. So it's important that you're prepared, whether you're visa exempt or you're applying for a visa overseas. It's important that you're putting forward all of the information to the officer, and as you said, people who are coming in for the initial visits are normally fine to enter as business visitors, but it's important to of course be honest with the border officers and with the consular applications overseas, especially putting forward your best foot forward to ensure that you're not running into roadblocks in the future after the business is perhaps already operational. You're realizing you may have an issue with your entry into Canada. So no, I would just echo that that's really important.
And I think what's interesting to mention here is, a lot of people already have Canadian travel visas in their passports, possibly from maybe there's a previous business trip that you took as, for a conference, or maybe you obtained a visa to come on holiday to Canada. And frequently visas are issued for multiple entry to Canada and for the length of your passport. So sometimes you already have that visa, and interestingly, you can continue to use that visa despite maybe the original purpose of your trip has now changed because you've come on holiday, you've done all that, but while the visa is valid, it's valid. So that can be really helpful if you already have that visa from a previous application, and you can have a more streamlined sort of experience because you don't have to apply again. So that's something that's nice to see if you have it. Another interesting scenario that we do see quite a bit because there is, a lot of innovation happening in Canada and a lot of great educational institutions focusing on, areas that are kind of very popular. We see a lot of students who are, becoming founders while they're here in school. And when they graduate, a lot of them are eligible for an open work permit. But from there, where they've set up a company, they've been working on it while in school, they continue to work on it post graduation, but now that post graduation work permit is running out. That's another scenario that arises quite a bit. Where they now need to understand what are my options for extending my stay and being able to keep building this business. So we'll be talking about some work permit categories that can be leveraged later on. But that's sort of an interesting scenario we've seen happening more and more, as well as a scenario of students who say, you know what, I've started this company, I want to just keep building it. I think I'm done with school. They don't necessarily want to finish school. What does that look like? What does that change over to a worker look like? So there's a lot of different scenarios that do arise that will need, consultation with immigration.
In terms of the corporate checklist, we wanted to touch on some of the important themes that we see coming up from a Canadian immigration side that we know our clients are dealing with from a corporate side as well when starting the business. Because as we mentioned, there's a lot of the two are some of these considerations such as the business plan, ownership structure, whether or not to have office space, co-sharing space, benefits and compensation, tax compliance. These are all very important issues from the company's standpoint, but how the company makes those decisions, in our view, it is really helpful to be thinking about what you are looking for as a company in terms of looking forward. What kinds of employees are we looking to bring into Canada to this new Canadian company? It's important that you're thinking about and aware of the options that are available for the company for these workers when going through all of those considerations. So, in our view, the most important or some of the most important topics to consider would be the market research, access, the business plan, the ownership structure, how you are going to be paying the foreign workers, because sometimes our clients will structure it in a way where the employees are being brought onto Canadian payroll, and in other cases they're remaining on overseas payroll where there are other affiliated or related companies overseas, such as a parent company. So all of these considerations don't need to be decided before speaking to Canadian Immigration Council and speaking to us. As Alexandra said, it is often very, very useful for you if you're looking at potentially opening a business in the future, or maybe you're already in the process of creating that business to be aware of what options you may be limiting yourself in the future by virtue of, for example, of what the ownership structure looks like, if it's different from a parent company or if it's the same as a parent company from overseas.
Mm-hmm. So we thought it might be helpful to go through some of these sort of key checklist items and talk about some practical scenarios that we've seen arise and things to think about. And then when we go through later some of the sort of work permit categories and options, put those into further context for you. So in terms of market research and access and the business plan, these are, in my view, pieces of information that make sense just generally outside of any immigration context to have done your research on before you decide to start a business in a new country. If you don't have a clear idea of what the market is like in Canada, and you haven't put that information down into a structured plan that goes over, who are your competitors, what sets you apart, how is your product new or different, or your service that you're offering, what are your KPIs for the first 3 to 5 years, how are you financing the project, all of these things need to be known, I think, before you would make that decision to start a company. And then having those, at least at a preliminary level at the outset, will then help inform the immigration strategy. As you'll see later, different work permits have different sort of requirements, and at least coming to the table with those ideas can be helpful. In terms of ownership structure, if this is already an entity that is going to be connected with a parent outside of Canada, or perhaps the person is already an owner of a few unrelated companies, it has to be decided how is the ownership going to work vis-a-vis those other entities. Is the Canadian company going to be a branch, or is it just going to be sort of a registered branch of the foreign entity? Is it going to be a subsidiary? Are there going to be new owners brought into the picture? Immigration has very specific definitions of what is considered to be an affiliate, a subsidiary, for the purposes of some key work permit categories. So understanding how you want to set up your ownership structure for other business related reasons and how that plays into the immigration strategy is very important at the outset before even deciding to incorporate.
Office space is another important consideration in my experience. Again, looking at potentially important and work permit options, office space, having a commercial presence, or potentially a co-sharing space may be adequate, but looking at and being mindful of whether the decision of whether or not to have office space could significantly impact what work permit options are available is, again, really important. If the company again, the company doesn't need to have these decisions already in place, and in our minds, it makes more sense to have the conversation with the knowledge of what the consequences would be from a Canadian immigration side.
Mm-hmm. We've seen a lot of businesses that maybe weren't already doing so move to a fully remote workforce in the last 5 years or so, and this has had some consequences for when they do want to hire foreign workers and they want to offer their foreign workers the same I guess benefit, you could call it, as the local workforce. But in many situations, immigration's policy is requiring a reasonable justification for why you need a worker here if they can work fully remotely. And they've actually explicitly stated in one such circumstance that time zone, preferences is not in itself a justifiable explanation. So, understanding where you might be bringing workers from to help start the company or help expand the company or bring in new knowledge is really important, because each sort of nationality has its own options available, whether there's a free trade agreement or whether there's not, or you have to do a labor test. All of these different immigration categories have different rules. It's not a one size fits all. So office space, I would say, is like one of the biggest decisions. And also, it's an expense. When you're starting a business or expanding a company, you want to keep those costs low. You're not necessarily sure how much space you need. So luckily there's been some flexibility with respect to usage of, these co-shared office providers where you can either, rent a day-to-day use desk, or a lot of them offer, um, private exclusive use offices, which has been really helpful to help keep costs down while also meeting immigration requirements. There's quite a few in Canada, which, we've seen they can even offer like a floor plan to help prove to immigration that you have that exclusive use office space where necessary. So that's a really, I think, a big consideration that a lot of companies spend a lot of time on. In terms of benefits and compensation, as Peter had mentioned, some businesses will choose to do like a split. So, it's perfectly fine to keep an existing employee, if it is a multinational enterprise, on foreign payroll and perhaps offer them some compensation in Canada, maybe to help account for cost of living differences. But as you'll see as well, sometimes this leads to issues because companies will set compensation before turning their mind to the immigration considerations. Many work permit categories have what we call a prevailing wage requirement. And even where it's not required, immigration will say it's still an important consideration in the overall assessment of the file. If you're either paying a foreign worker too low below our prevailing wage, or even too high sometimes, it can impact the assessment of the work permit. And I've seen companies, the wage is negotiated, it's set in a contract, then they find out, oh, our work permit category has a mandatory wage requirement, and then it's a whole new negotiation and everyone has wasted their time. So it's really good to figure that out, know the information before you start getting into contract negotiations for relocation.
Yeah, and and then for most of the work permit options that you can see under section 2, wage is going to be assessed for, I think, all of those actually. So it's a very important consideration that should be considered by the company, as Alexandra said, before going into those. And it's in everyone's interest to have the consequences of how you're paying your employees front of mind from the outset.
Mhm. I think in terms of the reasons for, expanding your business in Canada, there's many. There's building out an R&D center, taking advantage of Canadian local talent, expanding market access, maybe opening a sales office. Perhaps you have already secured a client contract and that client is requiring you to be locally based. There's perhaps you're trying to take advantage of a free trade agreement and cut on duties and taxes, who knows. So there's a lot of different reasons. All of those are perfectly valid. And really it comes down to ensuring that with whatever materials are being put forward, it makes sense, it's reasonable, and it's quantifiable targets, right? Because you're entering the market, you're probably going to have to get a few work permits for key people you want to bring in. And those work permits are not open-ended. They do need to be extended. So anything we're putting in the initial application needs to be vetted up front. And you need to have a really clear understanding and plan in place. I think a final note I wanted to make was about impact on pathways to permanent residency. So a lot of people that enter Canada want to, at the time, they already know they want to stay, or after living here for several years and maybe the business is doing really well and you've grown accustomed to the community that you're in and you'd like to stay, you might want to apply for permanent residency. Wherever possible, we do like to consider that future intention when we're assessing, what's going on with the business and what work permit categories might be available, because being considered self-employed can have an impact. The level of oversight that you give yourself from the outset can have an impact. What occupation is chosen to ground the work permit has an impact. Canada's permanent residence system is highly complex, very fluid, very changeable. So being as strategically aligned as possible is the goal. It's not always possible to, have a very clear idea, but there are some things that can be taken into account.
And then I would just add maybe on the point of extensions, Alexandra just mentioned these work permits are temporary, so you're usually looking at about 2 or 3 years, sometimes 1 year, depending on the work permit category. And the extensions are in the context of the Canadian government reviewing those applications to extend those workers and those work permits. The government will be looking back toward what was initially included in those business plans, in the market research, in the KPIs. And so it is very important to set up not only the successful entry of the temporary workers in the short term, but also in the long term as well. Really putting forward a comprehensive, realistic business plan. It's going to benefit the company and the applicants again in the short term, in the immediate future, and then in the long term as well.
Yeah, exactly. So I think perhaps we can talk a little bit about the actual strategies for work authorization and options that are available to help sort of put some of this into context. Yeah. So the first, Peter, I'm not sure actually if you wanted to talk about short-term entry now, or just touch on it to maybe give a
Sure.
use case for that.
Sure. So work authorization in Canada can take the form of a work permit, Canadian work permit, that's given to a foreign national, or work authorization. There are work permit exempt categories where a foreign national still holds work authorization in Canada. So there are a number of different categories under 186 of the regulations. Business visitor is one of those provisions under 186. So we've already touched on it briefly. If you're entering Canada, you're not entering the labor market. You're not performing hands-on work. So in other words, you're going to business meetings. Usually the business visitor category is sufficient. So in that case, you're not being given a work permit. You're going to be allowed entry and either given what's called a visitor record, or you're just going to be allowed to enter without being given documentation at the border by the Canadian Border Security Officer. There is another notable work permit exempt option, and that would be short-term entry under the Global Skills Strategy. So this is a useful option if you have individuals looking to enter Canada for short periods of time. So if they are considered and performing high-skilled work in Canada, they can enter for 15 days every 6 months, or 30 days every 12 months. And that this is a useful category, that in the sense that these are relatively less complex applications than a full, some of the work permit options that we're going to be going through and that you can see on the slide there underneath.
Mhm.
But the limit, or the potential practical issue is the short-term duration of that GSS option, and then the inability to use that again for sometimes, in some cases, significant periods of time, significant for the companies that need workers to enter Canada.
It can be used strategically. I mean, there are a number of countries that, for example, require a consular work permit application for a worker to come in. But if they are leveraging entry as a business visitor, or this short-term entry that is work permit exempt, they may be able to fly into Canada on an ETA. There are some sort of like visa exemptions for certain countries, and do some short-term work while they're waiting for a work permit or otherwise. So we'd use it, strategically here and there if there's like an urgent need for someone really key to jump in to a project and then jump out, and then wait for consular process where appropriate. So it's a really great program. We love it. So I would say one of the most frequently utilized work permit options for new businesses setting up in Canada is the intra-company transfer. The reason it's been so widely used is because it basically applies to all countries. There are regulations that govern it under immigration regulations, and there are also intra-company transfer specific work permit agreement options under free trade agreements. So there's like various pathways that can be used depending on the nationality of the worker, and each one might have slightly different variations in the requirements. But overall, the general criteria is the same. So it's essentially, if there is somebody who has been working at a company outside of Canada that the business wants to transfer to a Canadian branch, subsidiary, affiliate, or parent, and that person is a specialized worker, a manager, or an executive, um, they can do that. So they can transfer them on a work permit. The definition of what is considered a multinational company to be able to effect such a transfer does vary depending on the nationality of the employee. So some companies might be restricted from using this category if, for example, Canada is going to be the first entity that will create a multinational enterprise. What I mean by that is, let's say your business is currently only existing in India, and you want to open a company in Canada and transfer an employee from your Indian entity, you will be restricted because you're not yet considered multinational without that Canadian enterprise. So there are some restrictions on it, and that's why we have other categories that are available. Strategically, some businesses have said, okay, then I'm going to see if I can expand into another country first. And once that country, or once that, new business, let's say in the UK, has taken off, I'm already multinational, and then I will transfer my employee to Canada. I'll put a sort of pause on my Canadian expansion, expand elsewhere, and then do that. So there are other sort of longer term ways to get the plan done. Some intercompany transfer categories have a prevailing wage requirement and some do not. Typically, specialist workers are expected to be paid at least what is considered prevailing wage. what a prevailing wage is, it's basically if the government collects data from regions in Canada for similar occupations in the area, does a wage assessment, and it's the median wage for that occupation, basically to ensure that wages aren't being suppressed, foreign workers are getting, paid fair wages. That's the concept behind that. And it also is looked at by immigration to say, well, if this worker is so specialized, let's make sure that their wage matches that.
If I could just quickly add and maybe bring it back to one of the items on that corporate checklist that we went through at the beginning of the presentation. We were speaking about ownership structure. Ownership structure is going to come into play with respect to whether the company in Canada will be construed as a branch, subsidiary, or affiliate. If that ownership structure and the company in Canada does not meet one of those definitions, assuming there's a parent company overseas, and the Canadian company is not seen as a branch, subsidiary, or affiliate, this option would be taken off of the table. So there are only limited work permit options that that are going to allow a company in Canada to bring in a foreign worker without testing the labor market. And so in our view, the company should be aware of some of these decisions again in advance. So, okay, if we're structuring in a way where we are removing the ICT, we're aware of that, and we're aware of we may need to do a labor test in the future to bring in foreign workers.
Mm-hmm. And it also sort of this category obviously ties back to the consideration of how the Canadian business ownership structure is set up. If you are deciding to expand our existing company that you have established elsewhere and you have business partners, are your business partners going to be owning and controlling, this roughly the same proportion of the new company, or are there reasons why you're looking at having one individual owning, a majority and the others owning less? Those conversations, while, for business reasons, you might decide to do it one way, can impact your ability to use this category once the business has been set up. I've had numerous situations where the business has already been set up and then we have a consultation with the company, and they end up having to go back to the drawing board and make all these adjustments just to meet the definition, when had they known ahead of time they would have just made that decision fully informed at the outset. So it can save you money, time, headache to look at that first, and decide what to do. Yeah.
One
In
of the
terms
other,
of, sorry,
sorry.
Peter, go ahead.
Sorry. Yeah, I'll just maybe just introduce the topic. Free trade agreements are another offer another pathway for foreign workers to enter Canada and apply for a work permit. So you can see on the slide here, Canada has entered into a lot of these agreements with many countries around the world. Oftentimes the agreement will actually say the other country. Other times it's a kind of catch-all like CETA, which is the agreement between Canada and the EU. Also the CPTPP, right, with Australia, for example, Japan, Malaysia, Mexico. So what these agreements are essentially doing is they're carving out pathways for foreign nationals to obtain work permits and gain faster access into the Canadian labor market. So what we are considering when we look at a foreign national and whether they need a work permit and what type of work permit, these free trade agreements are a wonderful option because they do allow certain groups of business people to enter Canada in a relatively faster way than if the company needs to conduct a full labor test. So the group, in terms of the groups of people, there are business visitors. If you're typically a citizen of the other jurisdiction, Chile, Colombia, for example, the first two on the list there, a business visitor, there's a professional category under most of the agreements. So the government of Canada says if you're a designated professional as seen in the particular free trade agreement, you're going to be captured and you can access this faster, relatively simpler option of getting the work authorization. And then there is, as Alexandra mentioned, ICT options that are available in a lot of these free trade agreements as well.
Right. And I think just interestingly, comparing sort of the use of free trade agreement professionals categories, which will either encompass a specific list of professions that the free trade agreement has carved out as, allowing to enter, or an exclusionary list. So sometimes they'll say everyone except, doctors, or everyone except veterinarians. Everyone who's skilled except veterinarians are allowed. So they use different sorts of lists, but basically it can be a strategic choice if you have somebody who is, let's say, a Japanese national, and you're considering, okay, is this person going to be transferred under the intercompany transfer, or do we want to bring them in as a professional? It can be more streamlined often to use the free trade agreement professionals category because there are less boxes to check for their eligibility to bring them in. By doing so. So you're going to save time. There's going to be less documentary requirements than doing, the intracompany transfer for a startup business in Canada. And that's been one of my favorite strategies that I've used to sort of help bring people in faster, streamline the process. So I love the free trade agreements, big proponent of them because of that. And there are so many different options. There are also some, I think, restrictions to be aware of. So, for example, under CUSMA or USMCA between US, Mexico, and Canada, the agreement does not allow you to use the professionals category if you are self-employed. So, as a result of that, we end up using the investor part of the free trade agreement, which is set up for people that are owners. So there's different options, but investor again requires more documentation. It's a consular application as opposed to port of entry. So there are a lot of different considerations that we look at when we're assessing somebody's eligibility and the business structure. And there are so many different ways to do it. And we obviously look for the most strategically aligned and facilitative approach.
This particular type of work permit stream here is as you can see, it's the government is looking to attract skilled francophone workers and encouraging them to settle in communities outside of Quebec. So this work permit category in general is going to be helpful for you as a business in Canada, or if you're considering opening a business in Canada. It's important to know that if you're looking at bringing foreign nationals from France, for example, or from other countries, or really the country of citizenship is not strictly specified. As long as the foreign national can speak the requisite level of French and can demonstrate that proficiency, and again, assuming the place of work in Canada is outside of Quebec, this is a relatively, again, one of the faster, simpler options to bring that foreign national into Canada.
Just cognizant of our time here, we're gonna finish up our categories and then hopefully have some time for questions if there are any. So significant benefit is a very interesting category under the regulations. It's essentially aimed at situations that are going to have a demonstrable, significant social, cultural, or economic benefit for Canada. And the whole purpose of sort of all of these categories is that, there's a positive impact for Canada or a neutral impact on the Canadian labor market, such that no labor test is needed, because all of these categories we were talking about are labor test exempt. We keep saying that because if we cannot find one of these qualifying categories, it becomes much more difficult to secure that work authorization, because then a labor test is required, which sometimes requires recruitment. It requires referrals if you're part of a special stream, and it takes a lot longer. So we're not going to get into that today. That's a subject for a whole other webinar, but just to set this sort of stage for this, significant benefit is a category that can be really, really useful where there is such a clear reason and clear, compelling reason why someone, so an applicant who's coming in for a work permit, should be granted that work permit, because they're going to be providing unique qualifications, expertise, and experience, and injecting that into our communities, resulting in something significant. It's really meant for these sort of unicorn cases, very unique situations where someone has, let's for example say, accolades. They have scholarly articles. They are well known in their industry. This is for people that are really truly unique, and there can be tangible or intangible benefits. So it doesn't have to be, just job creation. It can be, increased mental health in the community, things like that. But it's really not meant to circumvent that labor test process. So there has to be like a justifiable reason why you're not doing the labor test if you want to use significant benefit, the C10 category. For C11, it's also falling under the significant benefit umbrella, and it's more for situations where somebody controls at least 50% of a business, and they're coming into Canada to start that business, make sure it's profitable and working, and then they're going to be essentially putting a succession plan in place and leaving. Or if they're, coming in to do something seasonally, like if they, seasonal businesses typically would be like maybe food trucks, camps, different things like that, that, can have a positive and significant impact on children, for example, and their experience in the community. There are parallels between the two, and often it can be difficult for us to identify which one we want to pursue. There's a lot of sort of fact-finding and information you have to look at, but ultimately they can be very useful for these special circumstances.
I would just add, again, being cognizant of time, everyone's time. The C11 is an option for business owners in particular. And what the government is increasingly doing with these C11 applications is they are keeping an eye on what the long-term intention is. So one of the facts that we would be considering whether C11 is the best category to fit someone in is there a temporary intention, or is there a transition plan to eventually leave the Canadian labor market? And so the government we see is increasingly looking at that. So that's something we would be mindful of when looking at the C11. But short term, we have had some success with this option, and it is useful for business owners, certainly.
I would just add, sorry, Peter, interestingly, there was a policy update to the significant benefit policy yesterday where the government has added more context. And the policy is there to help guide officers' decision making. And then obviously it also helps practitioners and people who are exploring it as an option to understand better what is required of them in such an application. And I think that update has been made because they're likely seeing an increase, probably a marked increase in its use because LMA processing has become LMIA labor market test processing has become a little bit less predictable, a little bit harder in the past few years, more so in the past year.
Mhm. Okay, so we only have just less than 10 minutes. The last work permit category wanted to touch on, again, these are labor test exempt work permits, would be the reciprocity category. This would be for businesses who there's two possible work permit categories here technically. One would be if you have a business in Canada and you have affiliated entities overseas, and the Canadian business starts sending Canadian PR, permanent residents or citizens, to those overseas branches. A case could potentially be made that, depending on the occupation of the Canadians being transferred overseas, that Canadians are being given opportunities overseas in other countries, and therefore a case can be made that there are reciprocal benefits, and foreign nationals should be allowed to come in and work at the Canadian entity. So this would be after the business is operational. We would canvass the possibility of using the reciprocity work permit category. Another related category would be the international experience class. So
Sorry,
these
Peter,
are,
just before
yep,
you move on to that, I wanted to just make a note. The reciprocal employment category can be really helpful for companies that, as you said, are already operating, and this is when we would start looking at it. But for new hires, so even if you've set up a operational structure or an enterprise structure that allows you to use intercompany transfers, there are many instances where you locate somebody who's a new hire outside of Canada and you want to bring them in. Instead of having to do the labor test, if you have set up a global mobility policy, you can use this category. So you don't have to wait for them to, work for the business abroad for 1 year to qualify as an ICT. You can immediately use reciprocal.
yep, that's a really good point. The last category I wanted to just briefly touch on was just that international experience class. The government of Canada has agreements in place with various countries around the world that allows for young adults, typically between 18 and 35 years old, to access the labor markets in each respective country, in Canada and the overseas country, in a relatively faster way. And so under the IEC, International Experience class, foreign nationals of those countries overseas sometimes do not even need a job offer in order to obtain a work permit. In other cases, they do need a job offer, but this is one other potential labor test exempt work permit category that could potentially be used if you're trying to bring in the overseas talent.
Thank you. And finally, importantly, also, a lot of people have families, right? And when they're moving to a new country, they're going to want to know, can I bring my family? In short, yes, they can typically bring their spouse, either married or by common law, and children. There are open spousal work permit options for spouses. Children that are not school aged can get a visitor record and or visa. And children that are school aged can apply for study permits. Interestingly, there are some specific rules around the duration of the principal worker's work permit. In many cases, they need to be applying for a work permit that is going to be at least 16 months in duration to allow their spouse to obtain that open spousal work permit. So if that eligibility criteria is not met, sometimes we have to pivot to, entry as a visitor. It comes up a lot in the intracompany transfer context for startup businesses, as many of the ICT categories limit the initial duration of the work permit to 12 months. Thereafter, it can be extended for longer. Some free trade agreements have special spousal provisions for work permits for the spouse, which actually allows us to get around that 16 months requirement sometimes. So there are ways to, strategize out of it. But those, I think, are the key items we wanted to mention in that regard. Unless, Peter, there's something else.
Nope, that's everything.
Okay. Shobita, I saw there's just one question regarding whether or not the webinar recording will be available. And I
Yes,
believe it
so
will be.
yes, so the webinar is being recorded and it will be shared on the Green and Spiegel YouTube channel. And that'll be shared out to all attendees as well.
Thank you. We wanted to thank you all for joining us today, and we hope that you found it helpful. We appreciate your participation.
Okay, I think we'll end the call here. Thank you everyone for joining, and a special thank you to Alexandra and Peter, of course, for sharing your knowledge. If anyone has any more questions or you want to discuss topics in more detail, you can reach out to Alexandra or Peter and book a consultation through the information on the screen. And I encourage you all to sign up for our e-alerts and follow us on social media just to stay up to date on the latest developments in Canadian immigration. Thank you, everyone.
Thank you.
Thanks, everyone. Goodbye.